The law dons, led by Professor Oloka Onyango and Associate Professor Christopher Mbazira, this afternoon filed their brief to court, raising 12 grounds that they think court needs to rely on in this landmark petition. They believe that their goal will restore the confidence of citizens in the country's democratic processes and encourage citizen participation in peaceful and credible elections that has been lost. The dons in their submission as AMICUS CURIAE assert that in light of the above, it's proper that in reaching a decision in this petition, the Honourable Justices of the Supreme Court take into consideration the various proposals for legal reforms it advised in 2001 and 2006 and to determine whether these reforms have been duly considered and acted upon by the Attorney General. The other grounds are partiality of election officials, deletion of the voters from the register without due process, failure or refusal by the returning officers to avail reports on time, contradictory and inadequate legal standards, level grounds for candidates, role of the security forces, and the historical inadequate electoral law. The basis for the law dons actions arises from the two previous presidential elections of 2001 and 2006, where Dr. Kizza Besigye versus the Electoral Commission and President Museveni, in which the individual justices made a number of specific and general recommendations regarding necessary reforms to the law required to enable the holding of free and fair elections, which can be said to truly express the will of the Ugandan public. The lecturers emphasized the need to ensure fairness and equity for candidates vying for the highest office in the land. The law dons demand that there should be equal treatment as provided for by Article 67, subsection 2 and 3 of the Constitution. The lecturers have cited the 2001 presidential judgment of the then Chief Justice Benjamin Odoki, who proposed that there should be a leveled ground to ensure that the incumbent does not enjoy an unfair advantage over the other candidates. The dons also cite the judgment of current Chief Justice Bart Katurebe in his 2006 petition, in which he similarly observed that there has been an inordinate enjoyment by the incumbent of the public media. The lecturers cite the recommendations of Justice Katurebe in his 2006 judgment, in which he suggested that the 20 days in which to hold a re-election are not sufficient for the Electoral Commission to conduct a truly free and fair election. The academicians quote the decision of former Supreme Court Justices Joseph Mulenga and Justice Odoki, in which they proposed that the electoral body be adequately empowered to perform its constitutional mandate to perform its statutory duties. However, Justice Mulenga observed that while the Electoral Commission is empowered under Article 61 of the Constitution to manage elections, the reality is that these powers are on paper only, as it can't exercise its constitutional mandate. On the issue of the security agencies being involved in the electoral process, the academicians cite the proposal by Justice Odoki in 2001, in which he suggested that the electoral process should be conducted in an atmosphere free of intimidation, bribery, violence, coercion, or anything intended to subvert the will of the people.